Hello, everyone. I am working on a just general opener like Baker has because I copy everything Baker does, uh, not as skillfully, to be honest. We are waiting for a hearing to pop up. It is supposed to be pop up uh, here soon, hopefully. And thank you, Alice G. Uh, awesome. Well, you know what? We don't have to agree all the time, but I'm glad that, you are willing to listen. And we have so many motions. Thank you, Jedi Jess, for coming through with all of the motions. So we do have Sarah Boone dropping all of the lawful law on the court. This judge has really set himself up for failure if he is making Sarah now in charge of, again, he is just setting himself for up for all of the letters everywhere all of the time. You know, that's the thing, Dennis Heaton. If she had her own, like YouTube channel and hadn't unalived anyone, she would be the greatest internet lolcow. I mean, she could be absolutely rolling in the dough because everyone hate watch. Just absolutely. Just you know, what it would be like Honey Boo Boo for the YouTube. It's not good for you, you shouldn't watch it, you should feel ashamed, but you still do. Mostly to feel better about your current, lot in life or, I may be hillbilly, but I'm not that hillbilly, like making sketty with ketchup and butter, which still turns my stomach. But there you go. We have all of her motions. So this is her motion to lawfully receive, utilize the original hard copy discovery, two boxes, A and B, submitted to the court by former attorneys on June 28th, 2024. Now, the judge talked to her at the end of the hearing. Sarah has made a big hullabaloo about being in a, public dormitory where she only has a small little cubbyhole to keep her personal items. And she was okay with the thumb drives, but now she really, really wants thank you for joining the Church of Mo Farm Sim. And we have dark chocolate and dark humor, but no patchouli oil or, those plastic recorders you have to play in the third grade. Look, I've been tortured by those enough. They are audio assault weapons for the masses. True. But I mean, Sarah is so contradictory in what she wants to do. First, she says she has no privacy. I mean, what is she expecting? She's going to get her own legal ensuite? I mean, at this point, what does she want? She's, complained to the court that she doesn't have privacy, she doesn't have a secure place, but now she is absolutely indignantly asking for these hard copies. If this isn't a stall tactic, I don't know what it is. I mean, unless she's kind of like a hoarder and she has to touch everything, herself before it is, adjudicated elsewhere. I don't understand, but she's so contradictory in what she wants that I think the judge is a bit confused too, because he did make this statement to her. You have complained about your lack of ability to keep things safe, and now you want these two boxes. I don't know if this seems too strategery if she's trying to create a plan in which she loses the hard copies and therefore needs a continuance, but that could work. Comes now Sarah Boone, pro se indigent defendant. She doesn't need to write that every time. I think that the judge, when he sees the line paper and her handwriting, is just like, oh, I know who that is. Respectfully request from the court to lawfully receive, review, utilize the original hard copy discoveries, two boxes A, B, submitted to the court by former attorneys on June 28th, 2024, to prepare for the preparation of trial in her criminal case. Lawful support and valid reasons for this request made by the defendant include: one, discovery definition. Oh, hell, she put more definitions in it. God love you, Sarah. Why is this not moving? All right, let's stop screen, present screen. I hate when these boxes are so small and you cannot see. Okay. We are having technical difficulties, but we will figure it out. All right, all right, now it's working. Oh, Lord, she put a definition in it. God love her. The definition of discovery: exploration or examination, finding something out by search or observation. Smart Communications Tablet Dictionary. B, the process of thorough or process through which attorneys acquire evidence in a case and encompasses practically everything an attorney may or must do under the rules of criminal procedure to acquire evidence before trial, and can be categorized such as documentary, testimonial, and physical. Bouvier's Law Dictionary still got that 2012 edition. 2, filed and posted to the clerk of court's website by the judge on July 9th, 2024 at 9:30 a.m. The evidence control sheet states: A, box of discovery; B, box of discovery. The court will reach out to the jail and to inquire how to deliver to the defendant and will provide a written order to release both boxes. These two boxes, A and B, are the defendant's original discovery she has not seen in full to the present date, and it is her right to receive by law uh, to fairly proceed in her defense. Now, what she fails to understand is that under oath, her investigative prison break guy declared by penalty of perjury that he has scanned every single thing in. Again, they are doing things to help her, like scanning all of this information in, accommodating the fact that she has made claims that she has, lack of privacy, lack of places to store things, and she is worried about, nefarious people giving information to the interwebs. I mean, it's just absolutely ridiculous. Uh, B, or let's see, and now she's telling him the rule. FRCP Rule 3.220 discovery states: B, sub 1, shall disclose to the defendant and permit to inspect, copy, test, and photograph the following information. F, if any tangible papers or objects that were obtained or belong to the defendant. B, or H, sanctions. 1, if at any time during the course of the proceedings it is brought to the attention of the court that the party has failed to comply with an applicable discovery rule or an order issued pursuant to the applicable discovery rule, the court or higher court may order the party or the court to comply with discovery or inspection of materials not previously discovered or produced, grant a continuance, grant a mistrial, or enter such other order as it deems under the circumstances. The willful violation, and then 2, willful violation by counsel or party not represented by counsel of an applicable discovery rule or order issued pursuant thereto shall be subject counsel or unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings against the attorney or unrepresented party, as well as the assessment of cost, defendant's time to prepare, incurred by the opposing party when appropriate. What, she wants to put the state in timeout? We all know that. Yeah, she's like, am I going to get my cell phone back? For the love of all that is holy. But that's my cell phone. She just does not get that she is in jail. 4, I'm sorry, C, not unreasonable or unduly burdensome or expensive given the needs of the case and the importance of the issues at stake in litigation. It's just, she complains about one thing, and then when you give her the thing that she wants, she starts complaining about the thing that she didn't want. Yeah, she's a dingus. The government is obligated under Brady and United States versus August uh, To disclose information in its sole possession that is material to the issue of innocence or guilt. The government places heavy reliance on the cases that hold information is material and therefore is reasonable in its probability that had evidence discovery been disclosed to the defense, the result of the proceeding would have been different. That's Bagley 473 US at a bunch of numbers. Any documents or requests made intentionally unavailable to the defendant through discovery and federal rules of criminal procedure are indirect violations of the defendant's due process with prejudice and shall not be denied, restricted, or deferred upon request by the defendant. By doing so, this constitutes intentional misconduct warranting sanctions. Again, this is not what they're doing. We've all met people like Sarah in our life where they complain about something and you think, okay, she's being a bit of a pain, but I can kind of see her point, and you fix that. And they go on to complain that you change things to fix them for them. Ish- She is an emotional vampire. And I think she just is used to being so insufferable that people give up and walk away or just let her have things so they don't have to deal with her, which is, I'm guessing, what her ex would do. But she has finally met a system that doesn't care how many times she wants to litigate little pieces of information. They are moving forward. She has finally gotten to a situation where she cannot annoy someone to the point of not caring. 5, by court only providing digital USB discovery to be viewed solely on a laptop provided by OCCD, and restricted to select time during the day only, motion for extended times in process. Without the necessary hard copies, the defendant is unable to A, review, research, investigate, build her defense at any time. Numerous hours are ineffectual and wasted by not having access to laptop and not having the original hard copies available to use physically during the laptop's closed hours. B, write notes, remarks, interpretations, explanations, make recordings of any kind. C, transport to meetings in any location, including the courthouse. D, make copies for distribution or any necessary presentations in court. If one form of the defendant's discovery is unavailable, the other should be available without interruption for unrestricted full access to equally at all times be able to lawfully prepare for her trial. Both are available to be provided by the court. Due to the court's error of not communicating with the defendant for most to have, she is going to call the court out in her letter and tell the judge he's an idiot. Wow. I mean, it's a bold move, Sarah. I think you're gonna roll a double one, though. And the jail prior to the implementation of order on June 28th, 2024, after the defendant's July 2024 letter questioning the location of her promised hardcover discovery or hard copy discovery to boxes A and B, as a direct result of her extended waiting period for the delivery by the court to expeditiously review, research, organize all context, and attempt to prepare all pre-motion trials as ordered by July 22, 2024. She is so salty about having to get her motions in by July 2022 or by July 22nd. She is so salty. The defendant is now forced in this abrupt manner to only receive and be restricted by the court to USB copies of her discovery. 6. It is an obstruction of justice to withhold this defendant's original hard copy discovery that has been complied for ongoing 5 years to properly, fairly, physically construct her rightful defense at all available times necessary to her and on the sole independent decision of the court, as the defendant, 1, did not ask for or suggest this USB only option. No, you didn't ask for it. You told them that you were in an insecure facility where people could steal your stuff. You were concerned about privacy, so they tried to help you, Sarah. And then you being yourself, you take a force multiplier and aim squarely at both of your feet and then wonder why you're bleeding out the next day and can't stand up. You giant dingus. 2, was not included in any decision-making collaboration or equal agreement for USB-only format to be received. 3, was never advised by the court prior to implementation of receiving only USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. Time, consideration, and inclusion could and should have been made on the court's behalf to uh, pre- prequel, prequely is not a word. I'm looking this up. Okay, I have put that, and no, there is no word called prequely. Avoid present disadvantaged circumstances, and the defendant would not be deprived of her due process and equal opportunities to correct, fairly represent herself, and oh gosh, succeed futuristically. For the love of God, futuristically and not intentionally are going to be the words I carry forward, Sarah. Whereas Sarah Boone, pro se indigent defendant, respectfully requests this to honorable court in conclusion, who lawfully receive, review, and utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28th, 2024, for preparation of trial in her current criminal case. By receiving the original copy or hard copy discovery, boxes A and B, in addition to the USB digital copies, the defendant is capable of viewing all discovery information available in continuous preparation of her trial, enhancing her ability to thrive lawfully in her forced by court position of pro se representation of self. She had to make sure that she got in there. That was not her choice. She was not intentionally pro se, futuristically speaking. And I am keeping an eye trying to see when this hearing is going to pop up, because it is supposed to be upcoming, but they keep not putting it up. Florida, stop taking so much doggone time on your things. Oh, it's on the website? Which one? Is it law and crime? I hate law and crime. Court TV. Ah. Thank you, Baker. And I should be getting my quiet clackety clack. Okay. Why am I not? All right, going there. Ah, here we go. No, I don't want to sign up for you, Court TV. No one does. I mean, allegedly in Minecraft. All right, let me pull this up. Stop screen, present screen, share screen. Where is the volume? We will be back since we are behind. Oh, he took off his coat. I'm so excited.
The exhibit list with our expected items of evidence that will be received, along with expected witnesses to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions, and a stipulation as to victim ID for her review as well.
Okay, and when was that provided to Mr. Lane?
Just now.
Okay, all right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good as well. Deputy Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
And yes. And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice.
So I am not sure. She did put a motion in to be able to move more freely in the court. I'm kind of hoping for the pink handcuffs to take another, appearance. But I can see how. Well, I found it. Thank you. Oh, Baker, you're right. Sorry, I thought you were talking. Marissa and I have the same name. So sometimes if I just read it, I'm like, yes, I will do that. And then I'm like, I am Mo here. So I almost get used to it. And then I'm like, yes, I will do that. And I was like, wait, he's not talking to me.
Provision of witness list, and then the notice of expected evidence and witnesses in trial. I don't have an order or.
It wouldn't be an order. It would just be that first document you read. Reference the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone?
Yes, they're broken down by folders.
And the folders, are the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well, as Mr. Lane has had an opportunity to copy for his client that I can tender tend it to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Castore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence?
I always feel like the judge waits that little pause because you're like, God, for God's sakes, I have to talk to her again. And it's a Friday and I'm this close to day drinking. I always feel like he says, ma'am, do you have anything else to add? With just a bit of trepidation, like the rest of us.
Witness is a trial document that was just provided to the court and yourself this morning.
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay.
We have to get the hat of truth and
Any other
tinfoil
questions?
on for
Yes.
Sarah.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some
got
of them
pink
come up as
handcuffs, y'all.
JPEGs,
Pink
some of them
handcuffs.
come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't.
Sarah, this is a hearing about, or sorry, Sue, this is a hearing for Sarah, and it's going over the discovery. It's going over some of her motions. She did ask that she be allowed to move a bit more freely in court. She does want the hard copies and not just the USB of her discovery and several other things. But we have the hat of, well, truth and tinfoil, because when Sarah's speaking, we don't quite know which is which. But I am going to give her a little bit of a pass as a tech flunky, that maybe she really doesn't understand how to do the laptop. So she's asking for the hard copies because, well, look, some of us have technical difficulties.
I don't know. I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're
Ask
not
for a
able to look
definition of
at?
majority.
It doesn't identify what they are because of the amount, when I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I
Wait.
try to click.
We have Discovery, Inception. Where is Leonardo DiCaprio when we need him? Hopefully, also Leonardo DiCaprio, young like Titanic, not new, older Leo that's still dating 19-year-olds.
On one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
Indigent pro se defendant. Lawyers document everything. You don't have a, low supply of pen and paper when you need to define something. You should have the exact file names with you. You should have the time and actions that you took to, try to bring those up. I mean, if this is just a factor of her not wanting to look like an idiot, this is your life on the line, ma'am. I would ask someone for help. I would also have documentation. I wouldn't just throw out numbers, but I'm not Sarah.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what for the most part means.
I haven't had time yet to explore everything due to the dorm.
Murdered for digging
No.
too deep. His death.
No one wants to hear you. We want to hear Sarah.
Because it helps with healthy joints and inflammation.
No, Tony
Why
Hawk.
Qunol? It has superior absorption.
How did Tony Hawk get so old?
Qunol, the brand I trust.
Why is America
No.
paying attention to?
Okay, stop it with the ads. I don't. Okay, maybe we're on.
This town happens to your town,
Oh, for the love of all that
and
is
this
holy.
house are felt in the heart of yours.
Every night on the race, we take you to impact.
We want to add some context around it.
No, I don't want you to add any
Nights
context.
at 6/5 Central on Scripps News. Watch
That's
with an
my
antenna
job.
or on your favorite streaming app.
We carried the legacy
What?
of those who paved the way.
Okay, we're going to see if.
Instead of just being a part of it, we are going to be a leader in
Look,
the sport.
you don't
we are
get mad
looking
at me.
forward to continuing to make
I am trying not to show your commercials.
Symbols
I
of
really am.
resilience and pride.
only the best.
Yearbook, a year-long salute to historically Black colleges and universities.
3, 2, 1, go.
Okay, can we get back to? All right. Does anyone know if there is not on the website? Also, a bunch of must-miss TV.
takes place on both sides of the aisle.
No, we already watched you babble.
These eyes.
The Race, weeknights at 6 on Scripps News. Watch with an antenna or on your favorite streaming app.
I am shocked I'm getting away with it, but I'm not saying nothing.
Let's get some order now. Hey, family. This is just fabulous.
Can we bring back Sally Jesse Raphael?
Live
I'm
from our
feeling
studio in
nostalgic in my
Missoula.
old age. What the?
Scripps News
How
takes
much
you ahead
news
of the
prawn do
headlines.
you have commercials for?
America Tonight on Scripps News. Find with an antenna or on your favorite streaming app.
8 hours of back-to-back true crime cases.
This is crazy.
On America's original true crime obsession. 48 hours on Court TV. Saturday
Let's see if
starting
we
at
get
4,
back
3
to
Central
Sarah
on
or
Court
we
TV.
learn more about our election. I give up. How can you have 12 minutes of... For the love of all that is Cheetos.
It's really important for script
I give up.
reporters that
How
live
many...
where they are reporting.
You got to talk to people
Okay,
from all
let's see
different.
if we stop sharing and then we go back and present. Yeah, it's still commercial, guys, and I don't want to get pulled down. I can now see how absolutely ridiculous it is when you have to sit through ads on YouTube, but... Oh, wait, Wait, are we back to court? Oh! They'll be right back. They had a little time to get some coffee or something. I mean, honest to goodness,
Welcome back to Court TV Live. We are watching a pretrial hearing in
yeah, I'm going to let them get done with their commentary because they do get upset when they're talking hats, or, well, talking hats, talking heads, continue with commentariousness and you steal that from them.
She has opted to represent
She has not
attorney because she
opted to rep-
didn't make things work with those.
Oh,
Let's get
for
you back into
goodness
the
sake.
courroul. The judge is going to be ruling on one of her
That's
motions.
all we
where
ever
she wants
wanted, man,
hard
was to get
copies
back in the
of all
courtroom.
of her files because she's in jail. She wants to be able to hold on to them in her cell. Let's go in.
Anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that
She's
jump
done
drive that was
talking. I can
tendered to
take
you
the
in
hat of
court this
tinfoil and
morning,
truth off.
and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her? If you know?
What sane human male goes in on a Saturday to see Sarah? I mean, that's like you lost a fight between doing naked burpees and a pool of Jell-O in Walmart, or you have to see Sarah Boone. And I'd pick burpees, to be honest with you. But that's just me.
Okay, all right. I have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Mohammed as well. Well, let me ask this. Are you able to go to the jail today?
I can, yes.
Okay, so I know for a fact that Major Mohammed is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave, it should be Major Mohammed, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Mohammed will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. Steve, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No.
Okay, so for the record, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
We're going to hit the pause button because we are about to reach the top of the hour. Small win there inside of the courtroom for the pro se defendants here.
Okay, you guys, I need confirmation on something as we're going to talking head lady. Let's see, stop screen, present. All right. I'm calling it. The judge has Angry Bird eyebrows, and I'm here for it. I mean, I honestly think that this is probably the best representation, but I will definitely be making a overlay with the Angry Bird judge eyebrows of justice. Now, Sarah does have another motion up, and we didn't get to that motion while they're just bloviating. We will. So she has made a motion to be out of the shackles or the cuffs and things like that. I do wonder if the judge is going to be amenable to this. I think she has acted with a bit more decorum this morning. She has been less argumentative. So okay. So it is a motion for defendant's reasonable freedom in movement by allowing her to be unshackled, unhandcuffed to function equally and comfortably while utilizing the courtroom. Now, I will say that I'm unsure about this. It will, I think, be something that the judge will have to consider. Thank you, Zach, for the super chat. I love my nickname. Comes now Sarah Boone, as we all know, pro se and indigent. Defendant respectfully requests from the court to be unshackled, unhandcuffed, and allowed reasonable freedom in movement to function accordingly, equally and comfortably while utilizing the courtroom. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of defendant's hands as a whole to freely, properly, successfully accomplish any task needed for. Prior to the entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographers, general public, Witnesses of the court, as well as vigilant armed deputies also in attendance, greatly diminishing the possible risk of flight or harm by the defendant while unshackled and unhandcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court. She just cannot let that go. She's gonna be like, not by choice, not by choice. And you know, allegedly, the court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested respectfully, seeing her in good faith. Well, sweetie, if you want the judge to maybe do you a solid, grant you a little bit of a favor, maybe don't, continue to call him an a-hole for taking away your, right to public defense. He hasn't taken away your right or your ability to get a lawyer. You just cannot have the public pay for one anymore. I mean, at what 70 billionth chance do you have to actually have consequences? Determined efforts to thrive and achieve her criminal case rightful, properly, and fairly. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court, in conclusion, to be unshackled, unhandcuffed, and allowed reasonable freedom of movement to function equally and in accordance to all of the people in the courtroom. No, Sarah, you are in jail. You are in jail. I understand that you in your mind are not a flight risk, but again, you have shown a propensity that when you do not get your way, you attack. We have records from your ex-husband. We have records, involving Jorge. I do have the domestic reports on all of them, and I will be making a video probably this weekend. But everyone is, not a safety threat until they are. And I don't know how Sarah will react when things don't go well for her in court. That is a worry for me. I do think she does not like being challenged. I do think that she goes ugly and immediately for, scratching using her nails. All right, we are back. Stop screen, present.
Thanks for following along with us.
Oh, not Julie Grant. I called her a tea waffle one time because I didn't know how to
The
work
judge is calling
Twitter.
in pro se defendant Sarah Boone to address her
I apologize, but you were
to
acting
the
like
court.
a
And this
tea
includes
waffle
a
man,
request to
so
come to court without shackles. But she is inside of that courtroom right now with shackles on her arms, connected to her waist. Let's listen to her raise that motion in front of this judge.
Matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Courts have the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay, so ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay,
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness. State.
okay, before we get to this, I do want to see how she is going to behave when she is asked to question a witness. I understand that this won't be, apples to oranges within the case, but I do want to see how she question someone when she feels like she is in her attorney mode, thereby feeling even more entitled. I can only imagine this is going to be an S show.
Call Gavin Wilson.
Yes, it's a corporal. I think he's part of court security.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LLWTAN.
All right, thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court security.
And how long have you worked that assignment?
Over 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done.
Not yet.
I don't have any personal knowledge.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court.
Wait, Sarah? Sarah was being a pain in the ass in jail? Shocked Pikachu face. And this woman who has been complaining, I don't get to go to my court cases. She's refusing to go to her court hearings. Ugh.
She still refused to attend those hearings. Those kind of, when you combine all that, to me it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Logan?
I do.
Go ahead.
First off, in your, in quotes, research that you've done on me, the
Oh, hell, did she just put on, in quotes, research on me? Oh, she started out sassy. I think she's going to get some shock shackles if she isn't careful.
domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never.
Wait a minute, then why do we have 873 letters of dearest honorable court Judge Wooten? I was not allowed to join this, trial update thing. And then it went to you stupid Judge Wooten who is taking money and running a cabal of internet people. Why am I not allowed to go to my trial progress meetings? Ma'am, you done wrote a damn dissertation about these.
I've never argued. I've never
And
hesitated.
object to the form of the question, Your Honor.
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her the date. Okay. On September 15, 2023, that was one of the times you refused to.
Damn it when they come with receipts, Sarah.
October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At
court?
the jail, yes.
Oh my God. We gotta on the record, for the record, run the record back. We might be in Daryl Brooks level by the time this trial starts. And if she makes a box for it, I hope she makes a bigger one.
Your contact, please. I've never missed a date.
This is a database that I got this information from.
Do you know when it was last updated?
I don't know.
What, does she think it
Okay,
was
so
affected
do
by
you know
pride
how-
or crowd strike?
I have never missed a court date to the present date. I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
For the September 15, 2023, it is Corrections Officer Portia Hines,
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It
To
doesn't say
attend.
specifically what your hearing is for.
Okay.
The second one, it'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene.
Yes.
10/16/23.
Yes.
Okay.
And the third one is January 28, 2021. And the officer is Jasmine Scribner. Scribner.
What are the comments, please, for Green?
At approximately 300 hours, I advised inmate.
No, this is the deputy in charge of security at the courthouse. So his reasoning, part of his recommendation that she not be out of shackles is in addition to her current charge, second-degree murder, she's also had DV complaints with alleged strangulation against George, and he is describing 3 times that she was non-compliant or difficult with officers when they were telling her that she had a court date, and she told them that she didn't want to go, regardless of there being a possibility of her being held in contempt of court. So she is disputing the fact that she never did anything wrong and she's always been at her court dates, which kind of doesn't coalesce with her screed of letters where she complains that she's not ever allowed to go to court dates. I don't know, I guess you complain about everything if and see what sticks to the wall like spaghetti.
Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward of the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28th?
At approximately 03:34 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay, so I'm trying to, and then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that isn't your history.
I understand, but I was never charged with.
Sarah, regardless of if you were charged with it or not, it shows a propensity to resort to violence when you don't get your way. Again, it goes into a sort of, framework that this officer is having to use to decide whether you're a danger. And he looks at those factors and he says, she gets pretty irritated and lays hands when she gets upset. I'm going to say no. You dingus.
Is that correct?
We are hitting the pause button on this pretrial hearing, and we're going to bring in trial attorney Krista Ramey. Krista, thanks so much for joining us this morning. We thought that
Wait
this
a minute.
motion to be...
What in the I am Pat are these glasses? Now, I speak as a person who wears the most ridiculous glasses, but holy fazolies, those are amazing. Let's see if we can skip on through the talking heads. Da, da, da. Or is she still talking and she's talking over her? Ugh. Let's see what Blondie has to say.
Or this deputy, or getting the right inferences out of it. Because what the guard came with, the receipts were the fact of her arrest and for second-degree murder in this particular case. That alone is not sufficient for shackling. We know that. Criminal defendants are almost never shackled under just those circumstances alone. A domestic violence charge that was later dropped does not show a propensity for violence that they should have, the courtroom staff should have any fear of her lashing out from, because if there was in fact...
Ladies, can we talk about this quite seriously? And I know this isn't a big point, but shoulder pads. Shoulder pads are the devil. I understand that this is a Murphy Brown thing for women of a certain age, but you don't need to look like a linebacker for the 49ers. I mean, those shoulder pads are at least 3 inches padding on her shoulders. You look powerful enough without the shoulder pads, ma'am. It makes your neck foreshortened, and they're terrible. Stop with the shoulder pads.
Violence in a domestic situation, that would be unique to that situation, right? And then we've got her refusing to come to court, and there's no inherent violence or acting out in those refusals. So you're not really hearing anything from this deputy that shows that there is a reasonable fear for security in this courtroom. And when weighing on balance her Fifth Amendment rights, I just don't see that this court could allow any kind of shackling for Sarah Boone. And, with a case like this, with someone representing themselves, you just got to be really careful as a judge here.
Krista, she needs you. She needs an attorney to help her ask the right question.
Well, This attorney was like, "You better get my name out your mouth and not tell Sarah Boone about me." Oh my god. That was the fastest do not throw my name in the hat. Her face went like, "Oh, hell no."
But unfortunately, she is at the point where
Look at
she's got to
that
do this
face.
herself. You're
She's
right.
like,
That's going to make it
nah.
where she has to stay at her defense.
Oh, okay, we're back.
Go anywhere. This is Court TV, your front row
Oh,
seat
no,
to
we're
justice.
not. All right.
Join Court.
So I will say that she is doing a little bit better than I thought, but here's the big issue. Sarah, you need the whiteboard of truth. Let's explain something to you, Miss Sarah. All right. Now, if you write a bunch of letters and you write them and you are, just crying your little eyes out because you can't go to the courthouse, then you cannot also say that you would like to stay in bed and not go to court, you giant dingus. You have an entire Dune level of books, chapters of books of notes of you not being allowed to go to court, and now it comes out that you actually voluntarily didn't go. You're losing your point. And for someone who says that, they are corpus mentis and accountable and a high school, honor roll student, and I'm sure honorary member of Mensa, she doesn't quite get listening comprehension because people have told her things. She has made statements and then she immediately contradicts them. And y'all, Christian, non-Christian, spaghetti monster in the sky, we all need to pray for these deputies that just got called out by name because Sarah is going to go up and try to speak to the regional manager. And that's going to be scary for everyone. I don't know. How do you think she's doing? I will say that she is actually more reserved and not as argumentative today, but it's early times and she's trying to challenge people about getting unshackled. I do see where Blondie of the shoulder pads is coming from. I mean, they don't have distinctly violent things that they can put on her. Okay, so Jedi has some info. I looked at the record, 9/14/13, the hearing was canceled. A new attorney entered their appearance on 9/16/2023. And then 10/16/2023, she didn't see a hearing scheduled at all. So I'm not sure what is going on, but I don't know that Sarah thought that they would have done anything, and she probably thought she would get, you know, higher treatment as a pro se defendant. Oh, okay. And Jedi says that 1/18/21 isn't the correct date. It's 1/28/21. Okay, so she refused that one. Let me write those correctly before I forget. Oh, I forgot I used the wet ones. Okay. Awesome, awesome. And thank you, Susan M., for becoming a new member of the Church of Mo. We have sarcasm and dark chocolate, but no patchouli oil or those little plastic recorders because those things hurt my ears. I do wonder if it amazes me that she hasn't had fisticuffs in Gen Pop. I don't know how this woman has functioned in prison with her general mindset and not gotten maybe checked by other states. I would not be shocked if they did not have her in somewhat limited, population. But she is just insufferable. And I do worry that she is gonna go up to each of these, deputies and give them a hard time, but the deputies have, written down what they're supposed to write down. It is not, they have to put something down, and we are back, thank goodness.
Charged with it, it was dropped, the charges were dropped.
But it is not on my record.
The arrest is on your record.
But the charge for the domestic violence is not on my record.
No, you were never
Just to ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it
Your Honor, I'm going to object to the form of the question. This is a statement, not a question.
Objection sustained.
Ooh. So this is the part that I think Sarah is going to have a very, very difficult time with. Forming questions in the correct way, and I think Cacciatore is about done with her, so he's going to be a stickler in the form of the questions. Hopefully she got that pro se litigant packet, but I think that my guess is his strategy in this, what I would do if I were a prosecutor, is very nitpicky and hope that the jury sees her when she's getting upset, when she's getting irate, get some of the true Sarah, kind of getting upset, angry, and that rage in there. And if they can get the jury to see a peek of that with the videos, I think she is absolutely cooked.
I guess I will provide information to you
Dear God, no.
for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever
Pretty much
documentation,
right.
but I believe that the decision as to
All right, I honestly think Sarah's playing a little dumb here. She might be wanting to get sympathy. Now, again, I don't know that I engender her with this much or give her this much credit for having, strategery in this way. But if she continues to put forth that she doesn't understand this legal process, that she's being forced to do this, she may actually get some sympathy, like from the defense attorney, that, I have been forced into this position, all, circumstances unrelated to myself. She may be able to sell that to some people. But I'm not sure that this is going to go over the way that she intends it, because she is a distinctly difficult person to extend grace to, just by means of her personality.
whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's up?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to ask and answer.
Sustained.
Okay. A lot of people with domestic violence cases, because of the very nature of domestic violence being something that's very hard to get out of, a lot of times victims will drop cases, go back to their abusers. In my world, that doesn't mean much. Just because you weren't convicted didn't mean that you didn't do it, that this, you know, thing didn't happen. No, it simply means that maybe your victim decided they weren't going to testify, you patched things up, or you are again stuck in that cycle. I take no, again, you were not adjudicated. I get that, but it still should go in as something that is in your propensity to do.
Okay. Do I provide this information to you?
You can provide it to the state.
Okay.
Well, Mads, I think that they would just have her legs shackled, just like Daryl Brooks. Her hands would be
Am
free
I,
during the court
in your
case, from what I understand.
A flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate.
We carried the legacy
For
of
the
those.
love of all that is Cheetos, we're back on. Oh, not Whoopi Goldberg, please. We are back on commercials. I don't understand. Okay, I am not a doctorologist. I'm not a psychologist. I am not even a phrenologist, one of those old people that used to touch your head and see if you had a criminal head shape by the bumps on your head. But does she just have like a innate inability to see anything that doesn't go with her I am poor Sarah victim, kind of narrative? Because she is willfully just ignorant and refuses to. She's like, I reject your reality and insert my own.
Women like you,
And
like me,
are
it's a great
80% more likely
disservice.
than men to live in
What I
poverty
think that's really upsetting is that
in retirement.
So here's
there
what we're
are
going to do
real
now.
women.
We're going
There
to
are
save
real
ourselves
women
by
and
setting a
men
goal to save
that
2% more of our income for our retirement.
actual DV,
Why two?
domestic
1% honors you.
And 1% honors all womankind.
victimhood upon
So come on,
herself when she
learn
is
more about the 2% challenge at
general
wesaysaveit.org.
at least 75%
Weeknights.
of the
Daddy and I have some exciting news.
Laugh More has a new man of the house.
Sounds like a plan that makes everybody happy.
And he runs a pretty tight ship.
You got blackjack. That pays.
I thought I had turned it down. If you want to know, apparently Matt LeBlanc is in a new freaking show, which is weird. Yeah, I just have the commercials going. Oh, I didn't stop screen. I'm a dingus. Never mind. As you were, people, as you were. I was wondering why you guys could, because usually I can hear it through the commercials. But I find it repugnant, the people that want to put on this victim cloak when they don't have that story. Again, there might have been bad things that went on in Sarah and George's relationship, but I find it much more akin to, Johnny Depp and Amber Heard than I do to, gosh, who was it? Joseph Fritzl and his daughter. Okay. I don't see a parallel. And I don't see it in her personality. I don't see it in the way she holds herself. If you've come from a situation where you have been in a place with a controlling partner, there are certainly personality things that you do. And I don't see her having that submissive, very hyper vigilant, walking on eggshells personality. And I know that everyone deals with trauma and things like that differently, but she does not optically come across as a victim. She comes across personality wise as astringent, stern, inflexible, and demanding. And those are personality traits that I would not associate with being a victim of DV. Now, that's my opinion.
Welcome back to Court TV Live. Sarah Boone wants her
Thank you.
She is representing herself in a trial in front of a jury, but security team there at the courthouse says she's got too many problems in her past. Domestic violence arrest and times that she was inside of the jail and refused to
Can
comply
you guys
with what
hear
jail
now?
officials asked her to do. So now we are listening to those arguments between the parties about whether or not those shackles should stay or leave, and the judge will render a decision.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Chad Gordon.
And not your date of birth, sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cup that is also used in the courtroom.
Okay, could you step us through what needs?
Oh my tiny baby Jeebus. Are we going to get shock shackles? I mean, did this just make my Friday? I might have a celebratory adult beverage this evening if we get shock shackles, y'all. I'm not joking.
Stun cuff is?
A stun cuff is an electronic device that's wireless. It's a box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There's a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons, no accidents. If it had to be used, it would cause a shock to the location on the back.
I have a question for the audience. Is this allowed? Can we have chat participation in this? Asking for a friend. Because Court TV, if you want to get your ratings up, see if you can arrange a chat interaction with shock shackles. Oh my gosh. This is why I'm not a judge.
Causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt? Other than what you've already identified?
Just to follow another response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment is at a level 3.
And what is a level 3?
3 would be failing to follow directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. Steve, do you have any questions to Deputy Barnett?
No, Joe.
All right, ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, and you can take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to the bag.
And it's a one-time waiver?
Each day you have to sign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply
Yes.
and remove?
Yes.
Thank you.
Any follow-up?
Nothing to say. Quiet.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. It's not the same thing.
And then I would be able to walk?
You would be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up, State?
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right, thank you, sir. State, any argument, any further witness?
You know, she actually did a good job. I mean, she did, point out that it's easy to use, that, she would be willing to sign a waiver until the day I'm sure comes that she has to sign a waiver, and then she'll be pissed off about it. I'm just, Mostradamusing it here, but she did do a good job with that. I think she is seeing, hey, if I work with people, people will maybe work with me. I don't expect this lesson to be a permanent one, but maybe she is getting more of a feel for the questions she's supposed to be asking.
Witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Sarah, this isn't multiple choice. This isn't a la carte buffet. The judge, what this hearing is doing is what most hearings do. You gather evidence because the court is supposed to be a neutral arbiter. So he wants to get evidence from the state and from you. He wants to get evidence from the witnesses, and then he gets to make the ultimate choice. This is, again, not an a la carte buffet. You are not at Country Buffet. You cannot go straight to the chocolate fountain and get that. No. The court is going to decide what the court feels comfortable with, but I'm sure that'll go right over her head.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would.
So, Star, the first deputy who was in charge of security in the court did bring up her current charge, which is second-degree murder. The fact that she was named and at least initially charged or arrested for several domestic violence issues with George, including alleged strangulation, around the neck. So he is showing, the first deputy that came in did show that she has a propensity for violence. Now, a defense attorney that was on court TV said that it wasn't something egregious enough that she would feel that the court would deny her using the shock shackles. But I do feel like look, Sarah is a dumpster fire human being, but she deserves to have a fair court case in so much as she will allow herself to have it. And the shock shackles will probably be what the court goes with, is what I'm guessing. Just because it does give the appearance of her being a, not an inmate, therefore not. Oh, okay, sorry. No worries. But I do think that the shock shackle will probably be how they go, but that's just me Mostradamusing it.
Come down to the argument of yourself and from the state as to what the court has to consider with regard to your request and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around.
That is how I took her motion as well. I do think that she's doing a good job at least clarifying that, if not in her motions, then here. And I think that is a reasonable request. If they don't want her to have a place at the table right now, I think at least making it easier for her to write notes. However, how dare she shame those beautiful pink shackles?
Prior, so you would know what it was that I was hopefully expecting. The first is just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that was why I was trying to be transparent and forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
We're hitting the pause button on this testimony. We do have to get to a break. Let's bring back in trial attorney Krista Ramey for a quick reaction. Krista, what do you think the judge is going to do with this case? I mean, there's the stun belt option, which we see sometimes, but it is rare.
Yeah, I just don't know. I don't think that she even knows what she's asking for, it sounds like now. She seems to be developing her.
What she should ask for is, obviously, she's having a hard time taking notes. I would like to be treated, if I am pro se, to be at the defense table. I do not want free reign of the court. I would like to be able to take notes. I would like to be able to access my hard copies while we are in these hearings. Would it be possible for me to be placed at the table so I may do that? But she is, she's not clear with what she wants, and that is the one thing that I have seen as I've grown in watching trials. You have to be very, very pedantic, very clear in what you want in legal motions, in legal filings. Look, I only promised to be her third-party intervener, and I have to take all my wigs, so I don't know if the state of Florida is going to be happy with that. Also, I require a lifetime supply of Diet Dr. Pepper.
Ask of this court while we're watching this happen, right? I think that initially, and this is how I viewed it earlier this morning when I was watching.
Okay, we're gonna stop that screen for a while, let her belloviate for a bit. I will say that I think, again, Sarah does not understand as much as she is compos mentis. You have to be detailed. You have to ask for exactly what you want. And I would have thought that she would have come in with a game plan, knowing that they were going to talk about this. She should have had case evidence backing her up. Again, she has Bouvier's Law Dictionary 2020 or 2012. It should have corresponding sections with how a pro se or a defendant, is able to appear in front of the jury without, implied guilt. It's difficult to understand what it is she's wanting, because she wants to have both sides of the field, I think. She wants the court to look as though they're not listening to her, they're not granting her anything, and she's being poor and trod upon. But this judge is doing a wonderful job of breaking down what she wants, of listening to her and giving her a chance to clarify that which might be confusing to him so that they're all on the same page. Because I think for me, I would have a difficult time dealing with Sarah's willful non listening and not comprehension of the rules. Yeah, that would be a statement that I would find confusing as a judge. You want to be able to walk up and hand up, you know, like, can I approach the witness? Do you want to be able to do that? What is it that she's asking for? And she doesn't get the level to which she has to specify. And I think that would be difficult for anyone. But instead of humbling herself and asking for, help for listening to any of her doggone attorneys, she has just been an insufferable butthead the entire time. So I believe that she got all of her motions in by the July 22nd deadline. Now, I think she will have to redress if the court rules against her having more freedom in the courtroom. I'm guessing she will have a time period with which to file an appeal or a motion of appeal to rethink that. I do feel like that the most likely course that the court is going to take is the shackle, again, to give her the appearance of not prejudicing the jury, uh, with her being an inmate. But the the media coverage on this is such that I don't know that they are going to find a jury, or it's going to be hard to find a jury. And I wonder I hope they video voir dire, because I can only imagine the things that Sarah is going to ask a prospective jury. Like, have you seen this on YouTube? Have you written me a letter? You know, how do you feel about justice? Are you compos mentis? I can just, absolutely see her going off the train tracks when it comes to voir dire questions.
Against her in the suitcase murder trial. Second-degree murder is what she is facing. Let's go back in, picking it up right where we left off with the arguments over whether or not she should be handcuffed going forward.
Would you also be asking the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here.
And someone brought it up in chat, but they had Ronnie O'Neill Jr., the guy that unalived his either wife or girlfriend, his young daughter, and attacked the son. I think he was given a chance to move around. So if they let Ronnie O'Neill Jr. walk around in court screaming about all the ridiculousness that he did in that trial, I do think that they are going to grant her motion in some way or form.
So yes, I would have very limited, reasonable movement in the courtroom for trial.
Okay.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay, state any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at a counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it.
I have not seen those. I know that Hella did a good breakdown of prior body cams, so you can go over to Excited Utterance. I haven't seen those yet. That is on one of my replay list. I doubt that they are going to bring in her prior criminal or her prior body cams because I think that those could be labeled more prejudicial than informative, but it would be interesting to see her argue that and whether she gets that kind of test that the court has to do, because I'm pretty sure she'll find everything against her prejudicial.
For today to address all those circumstances and again think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles.
Ma'am, they just went over 20 minutes of explaining how the setup is going to be in the court, futuristically, to use a word you love to use wrongly. They explained that the panel would be in front of the table, depending on whether they want to hard shackle you with a chain. The paneling in front of the defendant's table would conceal that you are incarcerated. Now, if they give you the shock shackle, then they will probably, give you some very set guidelines on where you can go and what you can do. We just had 20 minutes. Why are you asking this question again? This is why I got in trouble in school, because we would have 30 minutes where the teacher would explain something, and then someone would ask a question that the teacher just explained, and I would lose my mind. To be fair, I was that kid in trigonometry because I didn't understand not a daggone thing that was going on in there. And I'm sorry, Miss Fleener, but I have never used trigonometry in my real world, which brings me back to my point that getting a D in that class did not, ruin my life. I did a good job messing up myself without trigonometry, ma'am.
That as Deputy already identified, Deputy Lowen and Bulletin identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about.
Dang it, I wish I didn't have to pick up the kids because I would take a drink for futuristically because that is my favorite Sarah Boone word other than unintentionally. I do love futuristically. Yes. Why do all alcoholics think they are a genius? The problem that she suffers from is that she is marginally intelligent, but what is it, the Peter principle or where you achieve to a level to which you are incompetent? She is a midwit trying to be a full wit and sounding like a nitwit because she is working so hard to sound intelligent, to, sound as though she's in control, that she isn't even taking in what is being said to her. She is already working on her next statement and she's not taking anything in. So she misses a lot because she is attempting to put on a persona of professionalism that she should just, again, humble yourself. I don't know many things. I am fully, cognizant of the fact that I have no clue how to do math, and I wouldn't pretend to do math or give a trigonometry, stream. I am humbled enough to say that. She cannot and will not, because it will crumble the very foundation of the palace of Sarah that she has built up in her head.
Either way, with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, just address all the concerns, which is part of the court's plan.
Got it. All right, thank you very much. Well, I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first degree.
Are you in there? Open the door. Cam, come on.
Okay, well, we went directly into a self-deletion commercial, which was thanks for warning me, Court TV. But, I mean, I will say that she's doing a little bit better than I thought, but I do enjoy that this judge is being, I think, a better judge of a pro se defendant than Judge Doral was. I think he is firm, but he does explain things, but he's also not giving her a lot of the help that I think that Judge Doral gave Daryl Brooks. So I think he's setting a very firm set of boundaries of what he will allow in his courtroom, which is, I think, something that Judge Doral didn't do at the very beginning. So I think him starting out this way, being kind and firm, is a good way to do this. But that is just my opinion. I do love his angry eyebrows, though, and I can only imagine the amount of, let's just say, liquid courage he gets at lunch if he knows he's having a Sarah Boone hearing afterwards. This woman is exhausting. Yeah. Well, and she's gonna go directly back to the jail and hunt down those deputies who gave her a negative report. Well, absolutely, she does, so does Daryl Brooks. When you have this sort of personality, it's like dealing with a four-nager. If you've had children, 4 is the age that I always dread because they get enough, independence, personality that they'd like to do it all by their own selves. They will sit there and argue with you. But, again, you have to maintain boundaries. You have to be kind and firm. It's just like dealing with a toddler, which is kind of sad.
First, they've been bifurcated, so he's the first to go.
Huh,
Judge is
I
not
haven't.
allowing us to bring this trial live later today. We're also in Wisconsin watching the triple murder retrial for Naya Tao. He, of course, is accused of killing 3 men in a
Oh, yeah.
quarry back in
There were some
July
interesting
of
eyebrows in the
2021.
Karen Reed
And
trial, too.
we're in Massachusetts because defendant Karen Reed returns to court for a 2 p.m. Eastern hearing, and
Yes,
this
and
is the hearing that's going to focus on the
Baker will be covering the Karen Reed case. He has done an amazing job at watching all the hearings. He just has a wealth of knowledge, and his chat is so very kind in letting you kind of getting you up to speed. I went in on and watched the Karen Reed trial with Baker, and I was unaware of any of the players, and they did such a great job of getting me up to speed and really, giving me all the information. So head over to Baker's
defense motion
for
to
the Karen
dismiss
Reed
those
hearing.
2 charges after the jurors came forward and said they had reached
Absolute. And that
Okay, let
under
me
the
go back just a little bit. All right.
There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was a first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up in court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she is given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so now the court's going to grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be
Sarah Boone is unleashed. Well, hide your husband and fun-sized family members, because it's about to be lawful law in here.
seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, the only
Sarah, did you not just, you won. Stop talking. You won. You won one motion. Take this victory, run with it. But you are going to talk yourself out of winning a motion just here. I can feel it.
thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right. The other item I have Yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back, if that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that.
Yes, also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off.
In advance.
She gets up here.
Yeah, I agree. I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to?
It is under your clothing, as Sergeant Barnett identified. I have a representative.
Ma'am, okay. It would have to go attached to your skin. How do you think the electronic shock is going to go through your pant leg? Again, this is why I did not do well in school, because people would ask these questions and I would sit there rolling my eyes so hard that the earth, I think, lost a bit of the tilt on its axis. Oh, for the love of holiness.
From the public defender's office, who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Baker,
Yeah,
I concur.
what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you can do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand. And you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy? Or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office, or in the courtroom, so that there will be a deputy for basically your disposal, be seated closer to you, so that if you have a document that you want to bring to.
Okay, Judge, you better get that deputy that's personally assigned to Sarah the biggest muffin basket and Starbucks gift card, because that deputy, you're going to have turnover, okay? You better switch deputies on days. There needs to be a Sarah, day off.
The witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State, anything to clarify?
No, Your Honor.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024. A representative from the Orange County Jail sent email to my judicial assistant, email provided in the order. All notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today.
I absolutely think this is a smart choice. Sarah is going to try to claim that she doesn't have time, that she hasn't been given time, by making the prison, have the actual list outs of when she takes things out. He is going to be cutting her off at the pass, as far as this victim, mentality sort of, they didn't give me the laptop, they didn't allow me to do this. Since they're going to be now every Monday sending him, times that she's taken out the laptop, that she's requested to go to the law library, it's going to be on her. I mean, Letitia Stalk did the same thing in the Gannon Stalk case when she was pro se for a couple of minutes. She said she wanted to be pro se, but then she didn't want to go to the law library. And that was documented. So this judge is doing a good job at tying all these loose ends so Sarah cannot put forth any sort of narrative. So that is a really good point.
Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Damn it.
In
She always
regards
says
to
that.
the status report you were just speaking about regarding them providing me with the laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, and my concern was they're not stating what it was that I looked at for how long and
I don't know that they're going to record that information of the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
No, that would be considered privileged information since you are acting as your own attorney. The deputies shouldn't be marking down what you're looking at or anything like that. No, all they are simply going to say is that you had an opportunity to have this, and whatever you did while you did that is your business.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical.
All right, this Sarah Boone gets one answer.
Oh my glasses, what is this?
Harassed and not prejudged as guilty. So that's a big concern the court has to make sure they attend to. Otherwise, that's an avenue for appeal. And
okay, you guys, I have a lot of questions, mainly just where did this guy get his glasses and why did he pick those ones? Because he is a Midwestern shaped American like me, and those have to be kid glasses. That's it. I'm joining Court TV. I have plenty of weird glasses. I am there. I don't have a legal degree, but come on, Court TV. I have a ton of fun glasses.
the optics of this situation are going to be closely watched by Ms. Boone and everybody else, because whatever lawyer eventually gets any appeal is going to make a big deal about the conditions in which she was tried in front of that jury. It's already going to be difficult because behind her is going to be standing a couple of big burly law enforcement officers the entire time. So the judge does appear to be taking the right path, in my opinion. We'll see whether there's anything outward that would show jurors
or Liberace, I mean, at this point.
Her current condition as being an inmate. But I think the judge is taking a really reasonable pathway forward using the stun belt.
Next up is going to be Sarah Boone's motion to receive hard copies of all of the discovery because while she prepares to represent herself at trial, she wants all of it in her cell and
I thought
her
that we'd
access
already
to.
gone through this, but maybe I was missing something. I do think that the judge is doing a wonderful job of, really closing out those avenues for appeal. I I really disagree with Sarah about her hard copies. I I understand she wants them, but again, she has, and I thought they already took care of this at the beginning of the hearing by saying that she was clearing out uh, space in her evidence area, I guess, at the jail in order to have these. He could be mistaken. I think maybe those glasses uh, made it hard for him to listen to things like it made it hard for me to do. He did want his glasses to be coordinated with Sarah's cuffs. I you know, I feel sorry for whoever was in the eyeglasses shop and he was like, "Okay, this one or this one," and those were the ones they picked because if I was the assistant at the glasses place and he's like, "What do you think about these?" And I'd be like, "Do they make you feel special?" He does wanna make sure he is noticed. Uh, However, you would think you would wanna be noticed for not wearing your toddler's glasses. Or was it Bugsy Mogs that was really, really short in basketball, and I only remember his name because of, Space Jam? But he looks like, Chris Farley and Tommy Boy, big guy in a little coat, you know, little glasses on a big old head. Oh, no, he ordered them on Temu and didn't realize they were that small. I thought that they made I'm pretty sure that they did cover the paperwork because the judge was kind of like, "We're wrapping up this hearing, is there anything else?" But I believe they already addressed the hard copies because the Prison Break, uh, private investigator said that he was going to meet with, I believe, Deputy Muhammad at the jail. So I believe we might have already covered that, and they well, to be fair, I am terrible at, any sort of sports references, but I do remember Space Jam. Oh, I will say I love changing up glasses and having, like, my Emily D. Baker glasses and then, my Sally Jessy Raphael glasses. I think I even have some with crystals, so I could do the Elton John look. In fact, if this lawyer is going to be coming back on, I will bedazzle the hell out of a pair of glasses, and we will have Elton John glasses. 'Cause if I could decorate my house in a mix of Sailor Moon and Liberace, I would be there. I mean,
Welcome back to Court TV Live. I'm Ted Rollins. Glad to be with you on this Friday. We are watching Sarah Boone represent herself on a motion hearing
holy
in the
orange,
state of
sir.
Florida.
There's
She just found out that the
foundation that
judge
isn't orange.
is going to allow her to be hands-free when she represents herself when her trial begins. She'll have a stun cuff, is what they call it, taped to her. But otherwise, she'll be able to move around.
I don't know.
She'll just
I
stay
would
at
try to
counsel
trick her.
table, but she'll be able to,
Thank you so
in
much,
front of the
DB.
jury, appear as though she is unshackled. Next up for this judge is to decide another request that she has. She would like hard copies of the discovery in this case so that she could spread it around her jail cell and prepare for trial. Let's see what the judge decides. Let's watch.
Here is the fundamental problem with that. She does not have a private jail cell. She has made this evident in multiple filings. She has complained in multiple letters that she has no privacy, no autonomy over her area, and now she's demanding hard copies. is contradictory and a waste of time. But, you know, the judge is going to make an allowance because she is pro se and he doesn't want to have any appeals.
We did discuss the physical evidence, and I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. at courtroom 12A, Orange County Courthouse, and then the address of the courthouse. So the physical
Honestly, what I think she's going to go with is domestic or DV, battered spouse syndrome. And I think that absolutely optically, that is not going to work with her, with the general persona that she puts out. Again, she doesn't have a meek, submissive personality, and I don't even know that she could fake one for that long. If I were doing her trial, I would be looking for a plea deal of reckless homicide. I don't think that you're going to get anything lower. I would be pushing for that. I don't know what her strategy is going to be, but in all evidence points to Sarah is the victim strategy for me.
evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question, though, was, are you still trying to decide or research having the media?
Yes, ma'am. I've pulled the case law.
I will have
on
to
it.
double
I
check.
need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problems. The Miami Herald decision, I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that'll be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence. The digital evidence only.
of the 2 USB drives from Mr. Lane?
Oh, no, ma'am. The USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today.
Marissa, she has 14 days to go through the digital evidence, the 9 things that she is being given on the jump drive by the private investigator, and lodge any objections that she would have to any of that evidence. I don't know if that's maybe the Cellbrite. I'll have to look at the order. That might be the Cellbrite digital evidence that they were able to get off of her phone, but I guess it's something new that she'll have to also look at. Now, will she come back in and claim that she couldn't open the files? I do not know, but given her track record, probably. There will be something wrong. The dog ate her homework. The laptop didn't work. There was a CrowdStrike part 2 that just, came up and just broke her Chromebook.
State, do you have anything else?
No, no.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This is the letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with...
The problem with that is if you take custody of these things and then they get lost, that is just another reason for you to have issues. It is being there are protocols within jail. You are not the first pro se person. They are not going to let you have these things. Sarah, you are in jail. There are protocols under which you have to live. I am sorry that you feel that you are above it, but there are certain things and freedoms that will be taken away from you because of you being in jail.
Of course, the internet, if I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters. And
the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Berrios also send you a copy by way of the mail. It was already mailed. Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave? No, Your Honor. Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
Okay, Sarah Boone, defendant, and she's a pro se defendant. She's representing herself.
Oh, let me go. All in all, she did okay. She still has a very distinct inability to listen to anything that doesn't, I guess, involve her or, is beneficial to her. She is, again, like a toddler. You do not negotiate with these people. And let me see who I can send you guys to. I am going to be sending you guys over to Recovery Attic. I don't know what he's watching. It looks like Judge Boyd and maybe Young Thug stuff, as well as Sarah. So you guys will be going over there. Thank you so much for joining me. All in all, in my opinion, I think the judge is doing a wonderful job of maintaining order, setting boundaries in a firm and kind way, so that this court case, as much of an S show as it could be, I don't think it's going to get to Daryl Brooks level. But he really needs to stop asking her if she has anything else to add, because holy God. That is a trick question with Sarah. And yeah, she always has something to add. Thank you all for joining me for this hearing, and we will be, waiting to see what letters come next, because I'm sure she is going to argue something. She has her letters started. I thank you all for joining me, and I will be sending you over to Recovery Attic. Don't forget, tomorrow I have Legal Shenanigans Theater. We present a new interrogation, Elizabeth Wetlaufer, and it is Murder She Sharded, because I didn't think that we would find another more gassy interrogation suspect than Stephanie Lazarus, but this woman nearly cleared out the interrogation room. So if you enjoy interrogations with a little bit of humor, tomorrow at 3 p.m., we will be going over Murder She Sharded. So look into that, and I will see you guys tomorrow. Bye, guys. Oh, if I could find the button. I'm a professional, allegedly. Bye, guys. Futuristically, I will be a professional.